Since the plaintiff has the burden of proof, the plaintiff goes first in the opening statements. The opening statements don't look like the dramatic, argumentative things that you see on TV court cases, because you're not allowed to make arguments during your opening statement. You're only supposed to introduce your client and tell the jury a little bit about what the case is about, and tell the jury what you believe the evidence will show once the evidence has been presented, because there's no evidence presented to the jury yet, so you're not supposed to begin making arguments in the opening statement. So the plaintiff makes his opening statement. The defendant can then make his opening statement, or he can wait and present his opening statement later when he presents his part of the case. Then the plaintiff presents his evidence. He will examine his witnesses. When he questions his own witnesses, he's only allowed to ask what are called direct questions and not leading questions. A direct question is something like, did you see the accident? Yes or no. And a leading question is, you saw the accident, didn't you? Yes. So a leading question kind of fills in the testimony for the witness, and all they have to do is affirm it. And this is the easiest way to get information from a witness, because witnesses get so nervous sometimes on the witness stand at a trial, they forget their own names. And if they forget what they were supposed to say, if you can ask them a leading question, you can fill it in for them. But the rule is that on direct examination of your own witnesses, you are not allowed to ask leading questions. You're only allowed to ask direct questions. And it can be maddening for a lawyer when his witness gets all nervous and can't remember what they wanted to say, because you cannot help them out with leading questions. After the plaintiff asks his witness questions, of course, the other side is allowed to cross-examine a witness. And when you're cross-examining someone else's witness, you are allowed to ask leading questions. So, Mr. Smith, isn't it a fact that you were refused entry into the military? Yeah, what's that got to do with this? Well, you're the one that said the light was red when my client went through the red light and hit the other one, right? Yeah, it's a red light. Well, isn't it a fact that you were refused entrance into the military because they said you were colorblind? Oh, yeah. So, but those are leading questions, and not only do the rules change, but the strategy changes. The rule says you're allowed to ask leading questions on cross-examination, and the strategy is you only ask leading questions when you're cross-examining someone else's witness, because that way you control what they say. And you never ask questions on cross-examination unless you've already done your discovery and you already know what the answer to the question is going to be. So there's very few trials where there's this shocking epiphany discovery moment during the trial. The idea behind modern trials is everyone does their discovery and their homework before you get to trial, and there are no big surprises at trial. Everybody knows what's going to be, what evidence is going to go in and what testimony is going to be given, and that encourages trials settling, and it's good for everybody, including the efficiency of the court, the economy of the court. But on cross-examination, you only ask leading questions if you can, and you never ask a question if you don't already know the answer. And there's a famous case they used to teach that in law school. It was a criminal case, and the charge was mayhem, and that is maiming somebody in a fight. And what happened, there was a barroom brawl, and the defendant had bitten some guy's ear off in the fight. And there was only one witness, and there was an inexperienced young prosecutor and an inexperienced young public defender that had been given this relatively minor case to try. And so the prosecutor took his only witness to the fight and put him on the stand, and he said, "Now, you're the one that saw the defendant Smith bite off Jones's ear, right?" And the guy says, "Well, no, I didn't actually see him bite the guy's ear off." And the prosecutor says, "What?" He says, "You saw him bite the ear off, right?" He says, "Well, no, I didn't actually see that." Well, he asks him a couple more questions, and he can't get him to say that he saw the guy bite the other guy's ear off, and he's kind of dumbfounded. He's an inexperienced young prosecutor, and he just sits down. And at that point, all the defense, the only witness, and he hasn't testified to the crime. So the only thing that public defender has to do is stand up and say, "Judge, motion to dismiss for lack of evidence," and the judge would have dismissed the case. But instead, our ambitious young public defender stands up and says, "Now, you're the one that told the police that my client bit off so-and-so's ear, aren't you?" "Well, yes." He says, "Well, how dare you accuse my client of such a horrible crime when you didn't see him bite the guy's ear off?" And the guy says, "Well, because I saw him spit it out." Hung by your own defense lawyer. And that's how they teach us. Don't ever ask a question on cross-examination if you don't already know the answer.